Hello, I'm Ed Walters. I'm the Chief Strategy Officer of vLex and the co-founder of Fastcase. Today, we are going to talk about the ethical use of artificial intelligence to modernize legal services. I'd like to thank LAWIT for the invitation to speak today. As I mentioned before, I founded Fastcase when Fastcase merged with vLex in 2023. I became the Chief Strategy Officer of vLex. I also teach at Georgetown Law in the fall and Cornell Law School in the spring, a class called The Law of Robots, basically dealing with how law thinks about decisions that are made by artificial intelligence. This semester, fall of 24, I'm also teaching at Georgetown a class called Generative AI and Big Law, thinking about how the business model of law changes in the presence of tools that can do some of the functions of legal with artificial intelligence. Let's kick it off. So I think, as I mentioned before, I wear both hats, both as a kind of software developer in the legal tech space, as well as an academic. And I'm going to be talking about that from both perspectives. When you think about ethics and artificial intelligence, I think one of the very first cases that comes to mind, certainly in the US, but I think around the world too, is the case of Mata versus Avianca Airlines. By now, many of us know about this famous lawyer in New York named Stephen Schwartz, who used ChatGPT to answer client questions and who had hallucinated cases that he cited to the court. But I want to dive a little deeper because I think the story is a great illustration, not just of artificial intelligence, but responsible ethics across the board. And I want to have a little bit of sympathy for Stephen Schwartz as well. Let's tell his story. Okay, so in 2019, a gentleman named Roberto Mata was flying on Avianca Airlines from San Salvador to New York. And we feel for Mr. Mata because he was sitting on the aisle and the beverage cart came loose from the plane and careened down the aisle and smashed him in the kneecap, breaking his knee in the middle of his flight. So he is in excruciating pain. And he goes to see doctors to treat it when the plane lands in New York, but he's never really able to get the knee right. And of course, as soon as this starts, COVID begins. So Mr. Mata, 4 years later, goes to talk to a lawyer to try and recover from Avianca the cost of his medical bills. And his lawyer, Stephen Schwartz in New York, says, "Oh my gosh, Mr. Mata, I wish you'd come to me early because usually you don't have very long to bring a case like this. In the United States, there's a statute of limitations that says how long you have to sue. After that period, you may no longer sue a defendant." And in this case, it was 4 years later. Typically, for these cases, a treaty called the Montreal Convention establishes that there is a 2-year limitations period, which Mr. Mata was outside of. But there's good news for Mr. Mata because Stephen Schwartz says, "I dimly remember that for cases like this, if the defendant has filed bankruptcy, then that period pauses. The limitation period tolls during the duration of that bankruptcy." And in fact, Avianca Airlines had filed bankruptcy during COVID, preserving some time to file this case. And so Stephen Schwartz says, "I will use this provision of law to bring a case on your behalf in the courts of New York against Avianca Airlines to recover for your injury." Now, he just needs to find that provision. And so what does he do? Well, it's the beginning of 2023. And people have told Stephen Schwartz, artificial intelligence isn't going to take your job. A lawyer using artificial intelligence is going to take your job. He doesn't want to lose his job. He wants to be on the cutting edge. He wants to be on the forefront. He wants to use AI to substantiate this claim. So he goes into the only AI tool that he has in the spring of 2023, ChatGPT. He doesn't have like any of the fancy tools, CoCounsel from Thomson Reuters, Vincent from vLex. He has ChatGPT. And he types into ChatGPT, is it possible to extend the limitations period under the Montreal Convention if the defendant declares bankruptcy? And guess what? He gets back a beautiful answer. ChatGPT says, Stephen Schwartz, you are in luck. The law is exactly the way you imagine it to be. The limitations period is told under the Montreal Convention during the duration of a defendant's bankruptcy proceeding. And here are some cases that stand for that proposition. You can cite Varghese versus China Southern Airlines Company Limited, 925 F3rd 1339, 11th Circuit 2019, to stand for this proposition. And it pulls out like a quote from the case that says exactly what he is looking for. Stephen Schwartz says, this is amazing. Let's pause for a second. So it is early in the AI revolution for anybody, but especially early for lawyers in the spring of 2023. This is pretty early on. I also want to point out what a miracle just occurred. We might take this for granted today, but in Stephen Schwartz's entire career, legal research has never been that easy. And the answer he gets back is persuasive, it is succinct, it cites a case. The case citation is even perfectly blue booked. The citation follows the US Blue Book citation form. The volume, reporter, and page are from a reporter that would report the case from this court. The time frame is right. The volume of the reporter is right for that time frame. There's a lot going on here that is really astounding for Stephen Schwartz. Stephen Schwartz then, this is, so I just want to have some sympathy for Stephen Schwartz, okay? Like, so in his whole history of doing legal research, the way it has always worked is he tries to imagine what language a court or a legislature would use when discussing his issue. And then he does this fine computational linguistic operation, creating a mathematical string of words that would uniquely be in his winning case. This word within 4 words of this other word, and this word, or this word, or this word, and this exact phrase. Okay. After he does all of this work in the past, he gets back long lists of documents that meet that mathematical expression with precision, most of which are completely irrelevant to his research, a few of which are important, and a few important ones that didn't make it to the list. Okay, this is the state of the art of legal research in 2021, 2022, the way Stephen Schwartz has always done this work. And then from that long list, he must read some number of these cases. Nobody knows how many of the cases, to try and find these unique precedents in that list. Maybe it's number 19 and number 108 and number 273 in that list, but you might have to read 280 judicial opinions or statutes to find what you're looking for. Then and only then, after reading these judicial opinions or statutes, do you try yourself to synthesize what that means for your case. Okay, I'm not an apologist for this. I built these systems for most of the last 25 years. That was the state of the art in 2021 and 2022. So imagine the shock, the surprise, the relief when Stephen Schwartz types his question in natural language into ChatGPT and gets back not a list of documents, not even a list of winning documents, but like the answer to the question, citing a case chapter and verse, pulling out an exact quote from the case. This is the future. I mean, Stephen Schwartz is psyched. Okay, so I would just want to have like just a little sympathy for him. Now I think people tend to use him as a punching bag, but I just want to say, like, this is a real first kind of experience. In Stephen Schwartz's whole life, if he asks software a question and it has no answer, in Westlaw or in vLex or Fastcase, it would come back and say, no documents found. I found nothing with this search term. On the web, you would get back an error saying 404, page not found. But for the very first time in this case, ChatGPT did not know the answer, but it created a statistically likely facsimile of what a good answer would look like if it existed. ChatGPT is so eager to please Stephen Schwartz that it drafts a reasonable auto-corrected response to his question, showing what it would look like if it existed. Stephen Schwartz knows none of this, right? He doesn't have a New York Times article talking about hallucinations or some poor lawyer who got a case and it didn't actually exist from ChatGPT. He's on the cutting edge. No one knew. And so he is in the middle of this revolution, in the very front of it, startled, but he's being lied to, and he has no idea. Now, I just want to say at this point, this is kind of where I get off of the boat with Stephen Schwartz, because what he does next is he copies that response straight from ChatGPT and puts it into the brief. He doesn't read the cases. He doesn't verify that they exist. He cuts it from ChatGPT, he pastes it right into the brief and submits it to the court. And I think we all know what happened next. But if you don't, let me share with you, opposing counsel gets the brief, the lawyers for Avianca, right back to the court. And they say, Judge, we've got some issues with this complaint because we can't find some of the cases that are cited. It's not just Verghese, it's like 3 different cases that are cited in the brief, cut and paste directly from ChatGPT. The court writes to Mr. Schwartz and says, Mr. Schwartz, we've gotten this response from Avianca's lawyers, and by the way, we can't find these cases either. So what does Stephen Schwartz do at this point? Does he log into the free Fastcase benefit that he has as a member of the New York State Bar Association? He does not. Does he go to a county law library to look up the cases to ensure that they exist? He does not. Friends, I'm sad to tell you that he goes back to ChatGPT, where he asks, is Verghese a real case? And ChatGPT helpfully says, yes, Verghese versus China Southern Airlines Company Limited, 925 F 3rd 1339, 11th Circuit 2019 is a real case. And for those people who have studied in the US, by the way, this is a perfect looking citation. I mean, there's no indication there's anything wrong with the citation. It looks very real. What is your source? Schwartz asks. By the way, these are the actual screenshots from his chat session. These are pages from the sanctions hearing, from the documents. These are evidence admitted in his sanctions hearing. What is your source? He says. I apologize for the confusion earlier. Upon double checking, I found that the case does indeed exist and can be found in legal research databases such as Westlaw and LexisNexis. I apologize for any inconvenience or confusion. ChatGPT didn't check once, it assures him. It double checked to see that this case exists. Are the other cases you provided fake? He asks. No, the other cases I provided, says ChatGPT, are real and can be found in reputable legal databases such as LexisNexis and Westlaw. So, now we sort of know that ChatGPT was hallucinating. It was not looking for an answer to his question. It was auto-completing predicting what the next word would look like in a statistically perfect answer and creating an average answer to the question. It is not searching a database of judicial opinions and trying to find one that is relevant to return to Mr. Schwartz. It is starting with the word when and guessing what the next word is over and over and over again based on the entire history of the internet, apparently including citation guidelines, but not including judicial opinions. So this is a hallucination. And I guess I just want to separate this out, right? So the general AI foundation models like ChatGPT or OpenAI, like GPT-4o, like Gemini, like Bard, like Claude from Anthropic, like Llama from Meta. All of these are foundation models. And specifically what they do is exactly what I just said. They use autocomplete to create a statistically very likely answer. Now, as we'll discuss, there are fit for purpose tools that just do legal research that are going to look for actual precedents to prepare an answer. But the general foundation models, like ChatGPT, do not. And again, I don't want to dunk on Stephen Schwartz. I'm not trying to make him look bad. From the time that he was working, this would have looked like a very reasonable answer. Now, he has a responsibility to read and verify the cases, just like if a young associate had brought him that answer. Ultimately, when he files before the court, when he signs those documents, he is vouching for the validity of them. And he didn't do that here. But I think we can all see, because it was so early, this was a pretty easy mistake to make. And I hope, instead of condemning Steve Schwartz or making fun of him, I think we can hopefully learn from his experience and learn when it is ethical and responsible to use these tools, what they're good for, and what they're not good for. So I think it raises the question, if we're going to use these tools ethically and responsibly, do we need special rules of AI ethics? Do we need ethical guidelines from bar associations that govern the use of artificial intelligence, that tell us what lawyers' responsibilities are when they are using AI tools? Mark Twain, the American writer, once said, "History doesn't repeat itself, but it often rhymes." And I guess what I would say here is that we don't need a special code of AI ethics in any jurisdiction. In most jurisdictions, the existing rules of professionalism cover the use of AI. And in fact, in 2019, I wrote a law review article that discusses this exact point, that discusses how the rules of AI would apply, the rules of professional responsibility would apply to lawyers using AI. And I think in some ways foresaw what would happen like in 2022 and 2023. But I think that the takeaway point here is that we can use our existing rules of professional responsibility and those obligations to govern the professional responsibilities of lawyers. I'm going to talk a little bit about the model rules in the US, but this is true by statute in Mexico. It is true about the responsibilities of many bar associations around the world. The rules of ethics for lawyers, as you know, are codified in many different places around the world. But most of those rules deal with the overarching principles that govern artificial intelligence, which means for the most part, we don't really need new rules. We can follow the existing rules. I'm going to talk today about three highlighted guidelines. Think of these as guardrails for the ethical and responsible use of AI in practicing law. The first of these guardrails is accuracy. So we talked about this issue of hallucinations. This is effectively these foundation models auto-completing inside of a citation. They might say 357, the next word should be Federal Reporter Third, F period third, and then the next word should be 1159, and the next word should be. This is just creating what a good citation would look like, whether or not that citation actually exists. This is a problem with foundation models, but I just want to say that, as I said before, there are fit-for-purpose research tools that use artificial intelligence to find law, to use that law to answer questions, to cite law and maybe hyperlink it, to verify that it actually exists. But this is the hallmark for me. If we're using these tools as lawyers, we should guarantee for ourselves, to our satisfaction, that the raw materials, that everything that is cited in those answers is verifiable. And I would say in most cases, we have a responsibility to then go verify them. We have to go make sure this is a real statute, this is a real regulation, this is an article or treatise that actually exists. This citation to a judicial opinion cites to a real judicial opinion that we can find and verify that it says what it's supposed to say. And that is whether we're using the foundation models or the fit-for-purpose research tools. And I'll say a little bit more about that in a second. In the US, Model Rule 1.1 imposes a duty of competence on lawyers. Lawyers are responsible to be competent at their job. And under comment 8 in the US model rules, the requirement is that this competence includes technological competence. You have to be competent to use responsibly all of the technology that you employ in your work. Rule 1.3 in the US requires that lawyers act with reasonable promptness in representing a client. That might mean if you can do the work faster with artificial intelligence, you might actually in some cases be required to use it. Here I'm thinking about maybe electronic discovery. If there's a warehouse full of boxes of documents to review, Rule 1.3 might require that you use electronic discovery to review those documents instead of hiring an army full of lawyers and paralegals to read them all. And then I'll go back to what I said before, Rule 3.3, the duty of candor to the tribunal, whether this is codified in the individual regulations or statutes for professional responsibility in your jurisdiction. This should always be the North Star. We should always strive to be completely honest to the court, to regulators, to government officials. You can see the rule from the American Bar Association here, but I think this is a general guideline. When you cite authorities to the court, you are responsible with your duty of candor to make sure that that is an accurate statement of the law that you have verified. Okay. Principle 1, accuracy. Principle 2, transparency. So here, I think this obligation really is on the software providers as much as it is on lawyers. The idea behind transparency is that the software that we use, if we're going to use it responsibly, should share with us where the answers came from. One of the problems, a challenge of foundational models and ChatGPT is that it tends to be kind of a black box. You ask a question, you put a prompt in, something magic happens behind the scenes that we can't see, and then an answer comes out the other side. That is not a transparent solution. We don't really have the ability as lawyers to supervise what's going on there. We can't say, the steps that happen in this process are verifiable and accurate, and they represent a responsible way of finding an answer to this question that I can present to the court. Let me put it this way. In the US and in many places in the world, we have regulations that require nutrition labels that tell us what is in our food. We need to be able to see what the ingredients are and how healthy they are, whether they are full of fats and filler, or whether they have protein and good, responsible ingredients. And what I'm suggesting is that in legal AI, we should have some similar requirement that we can audit the process, that we can see what goes into making the answer. This is important. I know that there is a research tool that does generative AI. It's really for legal research recently. And they were giving answers in a way that was not transparent. And here is why it's important. Someone asked this legal research tool with the AI tool, what cases have applied this US Supreme Court opinion to the use of race in government decision-making? There is a big Supreme Court precedent. What lower court cases have applied that precedent later? And so the software comes back and says this Supreme Court case holds this about race-conscious admissions program. Lower courts have applied this to government programs and policies. In Doe versus State University, in 2025, the Ninth Circuit struck down a race-based scholarship program at a public university. In Smith versus City of Chicago, 2026, the Seventh Circuit upheld the city's minority business set-aside program. Now, if these were hyperlinks, we could click them and go visit the case, but we can't. If we could see how the court came up with this answer, what documents were used in creating it, that would help us to assess it better. In this case, the AI tool has cited cases from the future, which is a pretty good indication that they are not real. Of course, maybe AI is predicting, maybe the courts really will reach these decisions in the future, and then the joke is on me. But in either event, whether it is reading the future and predicting it, or whether it is just hallucinating, we can solve this issue of transparency by showing what goes into the decision. I want to draw a distinction here. I've talked about the difference between foundation models and fit for purpose legal AI tools built for legal decision-making, built for legal research and reasoning. And let me talk about the difference. I'm going to be a little bit nerdy about it, but what else would you expect? Okay, so the general foundation models, as I have told you, are really just predicting the next word. Their goal is to come up with a great average facsimile of what an answer would be. They are not truth engines. They are statistical likelihood engines. Legal research tools use a process called retrieval augmented generation, or RAG. It sounds very technical, but it's actually quite simple. The idea is we will break the question into two steps. Step one, find documents from a database that answer the question: judicial opinions, statutes, treatises, regulations, the same way we've always done in legal research, right? That first step is not fundamentally different from what we've done in the past. There are some interesting tweaks to it that I can talk about later, but that first step is really just find me documents that are highly relevant, that help answer the question. And then step two, we take the question that was asked, as well as some guardrails and guidelines, and then we pass those along with the relevant documents that help answer the question into a generative AI engine. And we say, answer the question using only the documents that I've sent you and nothing else. If you can't find it inside these documents, don't write it. Okay, and then that's the generation piece. First retrieval, find related documents, and then generation. Use these documents to answer the question in front of us. Retrieval augmented generation should allow us to do the transparency step that I was talking about. Look, I'm not trying to sell here, but I'll show how we implemented this in vLex. You can see the nutrition label right on the side. If I ask a question in vLex on the artificial intelligence side, we will find legal authorities that answer the question. And it's kind of a miracle. Instead of a list of 200 or 2,000 documents, we find two, like the real winners here. And then we pass those along with instructions, with guardrails, and we use that to answer the question. What I'm showing you right here is Vincent from vLex. And what Vincent does is this exact retrieval augmented generation step that I was talking about. Step one, let's find documents, legal authorities from the database that answer the question. And that's what you see down the right-hand side under legal authorities. vLex is multilingual. I'm using the English language version of it, but I asked the question in Spanish. I can ask it in English or Portuguese as well, searching over the laws of Mexico here, but I could search over the law of 13 different countries. But in this case, we are getting the most important legal authorities to answer the question. Here we found two. In some cases, it'll be 16 or 8 or 32, however many like truly authoritative documents we have. For each one of them, you can see the name of the document that's being used. Those are all hyperlinks, so I can click to it and verify it, that accuracy piece I was talking about before. They each have a summary of the entire document, so I can see what the document is about, followed by a confidence score, 70% for the first one, 100% on the second one. So I can see how confident Vincent is that this document helps to answer the question. And then in gray, you can see the exact phrase from this document. This is always an exact quote that helps to answer the question. That is the first part, the retrieval part. And by the way, like I think everyone gets excited about the generation. I'm really excited about the retrieval part. I think from a responsibility perspective, it's great that you can see it, that you can understand why it is one of the ingredients of the answer. But even before that, this is a huge revolution. In the past, legal research query like this, we would have to do that complicated Boolean search expression, and then we would get back hundreds of documents, tens of documents, thousands of documents, and read through them. Here, we don't have to do that anymore. But let's focus on the ethics from a transparency perspective, seeing the ingredients and understanding in a deep way why they are meant to go into the answer is very important. I'll add also, we're trying to build this in a responsible way. You can use the modify list button if you don't want to include some of these authorities in the answer. Maybe hard if there's only 2 of them, but if there's 17 of them and you said, I don't want to include these 3 when I'm making the answer, you can remove them. And then only the authorities that you choose will be used to create an answer to the question. Obviously, you can't do that with the foundation models. You can't even see how the answer is being made. I think Vincent AI is the only legal tool that allows you to control, which authorities go in. It's kind of like the picky eater at the restaurant who says, I want the salad, but I want the dressing on the side. That's probably the right way to order it. And you can do that. You have that kind of transparency and control in the tool. I'm not trying to sell you Vincent AI. I'm just trying to illustrate what I mean by transparency instead of a question and the answer just being spat out. I ask a question, and then I can see all of the authorities, and I can be an informed consumer, just like I might be an informed grocery shopper. I can be an informed consumer of these sources that go into making my answer. Here I've got the answer in English because English is my native language. Vincent knows that, but I can do this in Spanish or Portuguese or French or Mandarin. This works in the US, but also the UK, the European Union, in Spain, in France, in Portugal, in Mexico, in Colombia, in Chile, in Brazil, in Singapore and New Zealand. I suspect I'm probably missing a couple here, but in any event, this is what the future looks like, I think. And this is a good example of what I mean when I say we should include transparency and have that baked in. We are ultimately responsible for what we're filing on the courts. If we are to be responsible, then we have to be informed. We have to be able to see what goes into making the answer. I think we have to have control over what goes into the answer. And that's how we've tried to accomplish that in Vincent AI from vLex. The model rules in the US have a provision saying that you have a responsibility regarding the supervision of lawyers who work on your team. The major theme of that rule is that the lawyer who signs the paper represents that all of the lawyers who worked on it were properly supervised, and the signing lawyer takes responsibility. That same thing is true for people who are not lawyers. The model rules say that respect to people who are not licensed to practice law, the lawyer takes responsibility. They shall make reasonable efforts to ensure that there are measures that the person's conduct is compatible with the professional obligations of the lawyer. It basically means that the lawyer signing the paper is vouching for everyone, the lawyers on the case and everyone who is not licensed in the case as well. We don't yet have in the US, and I haven't seen it in the world either, a case where we have a Stephen Schwartz of Rule 5.3, where a court holds a lawyer responsible for failure to supervise software. But I think that can be easily implied from the Stephen Schwartz case. And we all want to make sure that we are not that case before the courts. Okay, I talked about accuracy. I talked about transparency. And then the third overarching theme I want to talk about is confidentiality. With the foundation models themselves, like ChatGPT, like Gemini, and like others, they get smarter every time people search them. And the reason they do is that the models are training on the answers. Everything that you prompt is used to train the model. Everything that is returned back is used to train the model. If you say it's a bad answer or a good answer, that trains the model. If you ask follow-up questions, that also trains the model. Why is that a problem? Well, obviously, if we're putting client confidential information into these foundation models, and that information is being used to train the model, that's a huge problem. As before, I want to draw a big distinction between the foundation models and the legal tools for legal AI that are fit for purpose. The general foundation models train on those prompts for the most part. The legal tools like Vincent AI or CoCounsel or others, by contract, do not train. After the prompt is submitted and the answer comes out, you can subscribe to versions of these tools that will flush everything immediately. So it's never training with the information that you put in. The foundation models don't have this feature. So by default, ChatGPT does train with your prompts. Gemini does train. I think it is possible to subscribe by contract to versions that do not, but it's trained by default. Why is that a big deal? Well, here's one good example. Samsung's R&D department said, I wonder how good of a job ChatGPT could do to help us create new patents. Here's a bunch of trade secrets that we're working on inside of Samsung. ChatGPT, help me create some new patent out of these trade secrets. Well, it turns out that ChatGPT was training based on the trade secrets. And so when later people would do searches or prompts that had to do with that technology area, they were getting back answers that included Samsung trade secrets. It is not just ChatGPT. Google's Bard engine said that it wasn't training with the data, but in fact, it was. So people's prompts were actually showing up on Google search results. In the US, there is a model rule that deals with this. It's Rule 1.6, governing the confidentiality of information, the confidentiality of information shared between a lawyer and a client. This is obviously not unique to the US. This is baked into the rules of professional responsibility in every jurisdiction around the world. And we just, again, need to be informed consumers. It's not that we can never use artificial intelligence, but we should say that we need to be very informed about how the information is used. And if the environment is not secure, we shouldn't put client confidential information in. Does that mean we can never use it? Of course not. You could use it to summarize non-confidential information. If there's a long statute or a case that you wanted to read and you wanted to summarize it, you could use ChatGPT for that. If there's some public file that is not confidential, you could use the foundation models to translate it, for example. All of those are kind of permitted uses, but if you have client confidential information, something that is subject to this duty of confidentiality, then you have to make sure that you're using a closed model, like Vincent AI, like CoCounsel, like others, so that you know that client confidential information is never used to train a model, never disclosed outside of that individual session. It might seem, based on all of these dire warnings, that I am negative on the use of AI in practicing law. Nothing could be further from the truth. I'm betting my career on legal AI. I think it shows enormous promise if used responsibly. And I think part of what we want to do here is to educate people on how to use AI in practice in a way that is ethical and responsible. But I want to underscore there is huge promise for the use of generative AI in the practice of law. Today's tools feel like the future, but in some ways they are the past. The tools we're using now, even like the most modern versions of GPT or Gemini, are the slowest, most expensive, and dumbest that they will ever be. The tools only get better from here. I also want to say on behalf of people who have ever had to do legal research the old way, there is great potential to get rid of this kind of Boolean expression that has driven us crazy and hasn't really created like very good sets of search results. Today, we have much better search results because of generative AI and are able to answer questions in a much more straightforward way. Look, our past as a profession is full of people misunderstanding the law, not finding out what the law is, people not knowing how to protect their rights. In the future, that will be much less of a problem. The law will become clearer and easier to understand because of generative AI. And this retrieval augmented generation that I talked about that we use in Vincent AI, but is also used by major legal research providers, really kills hallucinations dead. It makes sure that everything that is used to create an answer is hyperlinked and verifiable, that lawyers can see and control the inputs, that they can be informed consumers of that information that goes into the generative AI engines. And then, as we discussed, we should always make sure that the tools that we're using protect the confidentiality of our clients' secrets. If we can control for these three things, accuracy, transparency, and confidentiality, these legal AI tools have amazing potential to make the practice of law easier and more powerful and simpler for ourselves and for our clients. But we have to make sure that we're doing it ethically and responsibly. And my purpose today was to give some good guidelines as to how we do that, so we don't end up being in the New York Times for unethical or irresponsible use. I'm Ed Walters, Chief Strategy Officer from vLex, an adjunct professor at Georgetown University Law Center and Cornell Law School and Cornell Tech. Thank you to the LAWIT team for inviting me to speak to you today. Have a great day.